In other words, what you don't want to do is, while your case is pending, let's say your case is pending 9 months before trial, and then at trial you show up and your argument is you haven't lifted a finger to either get a job, to start school, or get any kind of training that would give you job skills, or even have a plan as to what you're going to do. That would give the other side a pretty good defense that since you haven't been diligent in trying to better your situation, that because of that, they have a defense to the alimony argument. So how much alimony can someone qualify for? Under the maximums, or maximum under the statute, the maximum monthly amount is going to be the lesser of either $5,000 per month or 20% of the paying spouse's monthly gross income. And note there that it's the lesser of the two amounts. So let's say you have somebody who makes $120,000 per year, the payor, which would be $10,000 per month gross income. And if any of you know anything about child support calculations, it's interesting. This statute actually bases it on the payor's gross income. The child support statute bases it on something totally different called monthly net resources. But in this statute, it's monthly gross income. So using that example, person that makes $10,000 a month, the maximum they could be ordered to pay would be $2,000 per month. If you take someone who makes a much larger income, let's say you take somebody who makes $600,000 a year or $50,000 per month, well then they're going to be above that cap, and the maximum that they would be ordered to pay is $5,000. So those are the maximum amounts, or rather maximum amount, and the maximum is just dependent on whether you are whether the payor has an income amount that is high enough to reach the $5,000 threshold. If not, then the maximum is going to be the 20% of the monthly gross income. I should point out here that the numbers that we're talking about, this is a maximum. In other words, this is the absolute ceiling on what a court could order. So if you're analyzing this, you don't want to look at it and think, well, I'm going to pursue alimony. My spouse makes $10,000 per month. Therefore, I'm going to get $2,000 per month in alimony. No, that's not what I'm saying. What I'm saying is that's the maximum that a court could order. The court could also order zero, but this is just the ceiling. So how long under the new statute can alimony last? This is a significant departure from the old statute. The old statute, as I mentioned, was a 3-year cap. Now the statute has been adjusted to apply different durations, different maximum durations, based on the length of the marriage. So, for example, if your marriage was less than 10 years, well, you don't qualify to apply for alimony anyway, so that's not addressed. But if your marriage is between 10 and 20 years, the maximum duration is 5 years. If your marriage is more than 20 years but less than 30, the maximum duration of the alimony is 7 years. And if your marriage is 30 years or more, the maximum duration is 10 years. As I mentioned, this is a significant alteration from the way the old alimony law used to be, particularly for somebody in a very long marriage with a very high income spouse. So in those kinds of cases, it could make a significant difference. If you look just at the gross amounts, under the old statute, the maximum, let's say you take somebody who had been in a 30-year marriage and the spouse made $500,000 a year and was over under the new statute, would be over the cap for $5,000. Well, if you look at those two comparisons under the old statute and the new statute, under the old statute, the judge would be limited to $2,500 a month for 3 years, which using, if you do the math, over a 3-year period, that's a total of $90,000 paid out. If you compare that to the new statute with those same facts, it's $5,000 a month for 10 years, which is $600,000. So in certain cases, this new alimony statute can make a very, very significant difference. I also think that it makes a difference in terms of, because the maximums are so much higher, judges, I think overall, average alimony awards are going to go up significantly just because they have the ability to go so much higher. $2,500, while that used to be the cap number, now it doesn't seem like it's that high of an award because the maximum is double that. That brings us to key number 3, and that is understanding separate property. This is an area that can make a huge difference in your overall property division outcome. So first of all, let's talk a little bit about what community property is and what separate property is. So there is a statutory presumption that all property that's owned by either spouse is community property, and community property is subject to division by the court, as I mentioned earlier, under that just and fair standard, that the judge is just going to divide up the community property however they think is fair. So the court, the starting point is the assumption that any property owned by husband, wife, or jointly, all their property, the presumption is that it is community property. However, you can prove that certain property is your separate property, and you can, in doing so, remove that property from the divisible community pie. So what is separate property? How do we prove separate property? Let's talk about that. There are 3 kinds of separate property. There's property that is owned by a spouse before the marriage. There are assets that you may have received as a gift or an inheritance. And there are certain kinds of personal injury recoveries. Those are rather rare. Let's talk a little bit about each of those. The property owned by a spouse pre-marriage, that is probably the most common area. And there are lots of complicated examples. There are also some simple examples. For example, an asset owned pre-marriage, like a house, for example, that would be an easy asset to prove as your separate property. All we would need to do would be to get a certified copy of the deed that showed that the house was owned prior to the date of marriage, and that one would be about as easy a separate property claim as you can make. You take the more common example that I see in my practice, which would be somebody that had, say, $100,000 in an investment account, and the investment account at the time of marriage had it had securities, it had stocks, it had cash, and then during the marriage, additional deposits were made to that same account, and then money was taken out to buy a car or to buy a house, and then dividends were paid and interest was earned. All of those things make tracing that asset much more difficult, but ultimately, property that you owned by a spouse pre-marriage is your separate property. You just have to prove and be able to trace it back.